Welcome, everybody. Ross McCorkle here, SteelersDepot.com. And if you recognize the backdrop, this is the Depot Dive, typically coming at you on Thursday afternoons. I'm joined today by Eric Donica, a lawyer. I'll let him introduce himself in a second, but the topic of the video, as you can probably see on your screen, is DK Metcalf's lawsuit that is currently open against him. $100 million Ryan Kennedy is seeking in damages. Of course, that is for the event or the altercation that took place at the Detroit Lions game earlier in the season. DK Metcalf walked over to a fan, appeared to get into an altercation with him, and after the fact, there were some allegations made. We'll get into the specifics, and yada, yada, yada. Here we are with a $100 million lawsuit against Metcalf and others. Eric, why don't you tell everybody a little bit about yourself, your background, and then we'll get into it.
All right. Hey, everyone. My name is Eric Donica. I'm an attorney in Nashville, Tennessee. Just to say a few boring lawyer things real quick. This is not supposed to be legal advice. We're just discussing a defamation lawsuit and what may be happening there. Also, I am not a defamation law expert. I can't hold myself out as an expert in that area. And then the last thing is that we are not attempting to perpetuate any alleged defamation or republish any defamatory statements here. We're not taking a position one way or another on who may or may not have said who may who may or may not have said what during the altercation.
Yeah, thank you. And this happened in Michigan, and of course, there's maybe some minutia to the law in different states. And like he said, he's in Tennessee, and so our goal here, this is not a court of law. We're not trying to litigate here in this video. We just, there's Pittsburgh fans out there that want to know what's going on with this lawsuit. Is there a chance that Ryan Kennedy could really get $100 million from DK Metcalf and others involved? And also, there's now some criminal, pursuits being put into place that the police in Michigan are, looking into this incident, even though it was months ago at this point. And so we want to talk a little bit about all of that and what it could potentially mean for Metcalf, for the NFL, etc. A little bit of background about this incident. Of course, DK Metcalf never actually came out and said what Ryan Kennedy, he would be the plaintiff. Is that right? I'm not. The guy who put the lawsuit forward, is he the plaintiff?
Yes.
Okay, so I got that part correct from my college law course, if I remember one thing. But he alleged that Metcalf, spread misinformation about him, that he used some slurs, and that there was some harassment involved because there was potentially a second incident dating back a year prior when DK Metcalf was with the Seattle Seahawks. Ryan Kennedy is saying that this damaged his reputation as a business owner. He's now receiving threats against his family as well for, if the slurs were used. That's obviously a pretty incendiary topic and could be damage to his reputation. And so that's what he is seeking damages for. But like I said, Metcalf never actually said those words. They were relayed through other podcasts, and one being the Nightcap podcast with Chad Johnson and Shannon Sharp. And they said that they spoke with DK Metcalf, and there were potentially some slurs used in that altercation that maybe made Metcalf react the way he did. And of course, also the James Harrison podcast, he went into further detail, basically confirming what Chad Johnson said. And so again, Metcalf never actually said this stuff himself. $100 million seems like a lot in terms of the damages they're seeking. Lawyers often start high and kind of settle low. And what do you think the chances are here?
Oh, I definitely agree that lawyers will often aim high and settle lower than they initially want. It does, of course, seem high, 100 million. Cases like this, to be honest, though, it's not theoretically impossible, given how much it could potentially affect his Ryan Kennedy's reputation, money he can make, because if it if people have thought, oh, this guy, he used a slur and another very vulgar term, he's must be a racist guy or a sexist guy or something, that can make you know a ton of people, an entire community of people, just not associate with you. You never get hired, you never get business, anything like that. So $100 million is really high, but I will say it's not theoretically impossible in a case like this.
Wow. Yeah, I that is surprising to me. Honestly, I would have guessed that it was totally just let's aim high and negotiate down. But what is the burden in a case like this? I guess we'll start with the civil side of it with the 100 million. In a defamation case, who has to prove what?
The plaintiff has to prove everything, which the first one is a defamatory statement, which is one that is capable of harming reputation or business interests or standing in the community, if the community now looks at you less than they did before. They have to prove it that the statement was false. So, I mean, the idea is you can say bad things about people as much as you want if it happens to be true. But so that's why they have to prove that the statement is actually false. They have to prove that the statement was published, which, in a case where things are being stated over podcasts and on news articles, that's a fairly easy one. But then there's kind of an interesting question about the state of mind element that one has to have, because depending on who the plaintiff is, Ryan Kennedy is as an individual, whether he would be considered a private person or a public person, a defamatory statement has to have been made either negligently, like you should have known this was false before you said it, but if it's more of a public figure issue, there is a state of mind requirement of you have to know that the statement is false when you say it, or act with reckless disregard to whether it's false or not. Um, so all of that is probably a bunch of annoying legal mumbo jumbo there. But if that higher standard applies, it's much harder for a plaintiff to win a defamation case. A plaintiff also has to prove their damages. So Ryan Kennedy would have to be able to show, you know, this is a job I lost because of this, and I was making such and such wage, or I owned this business and now nobody patronizes my business anymore, and I used to earn, millions of dollars a year, things like that. So you have to be able to quantify your losses.
I believe in one of the most recent press conferences or statements from his lawyer or whatever it was, they said that he is a mortgage company CEO, and so I guess 100 million you're saying would have to be directly tied to what he is actually losing. But I'm assuming he's not $100 million business owner. So then how is that exactly determined? Do they tack things on like emotional distress and all these other things to kind of push that figure up?
It can be pushed up, sort of, I believe, based on intangible damages as well. It's kind of there are other cases like personal injury cases where you can get your medical bills, but you also can get stuff that's hard to quantify, like pain and suffering damages, how much it's affected your life. You can't exactly put a number on it, but you can get money for that. I believe it would be similar in a case like this, where not only could you show an actual economic damage, but you could have a jury potentially consider an amount that they think is reasonable for simply the fact that now, you may be stigmatized and I think you were saying things about his family, things of that nature. The society looking at you differently kind of has a not exactly quantifiable damage situation, but could still get some kind of award just based on the simple fact that now you may be somewhat of an outcast, if that makes sense.
Yeah. Okay. I wanted to, I guess, zoom in on what you said about the burden. He has to prove that what was said is actually false. And that part is interesting. There's layers to it in this situation because in this day and age, of course, there is a ton of cell phone footage and social media stuff with these types of incidents. And of course, they surfaced in this one shortly after Metcalf appeared to grab or strike or whatever it was, the altercation with the fan in the stands. Cell phone footage didn't really reveal any of those kinds of statements, and so you'd think that that might work in Kennedy's favor. However, there was one video where he turned around and appeared to at least celebrate to the crowd, and I believe his exact words in the video, from what you could make out, was, I don't have it up in front of me, so I'm going to say this is a paraphrase, but he said, "That's what I was hoping for," or something along those lines. Like, he was celebrating it. That part was clear because he threw his hands up in the air, and, that's just what it appeared to be. And so, I don't really think that that has any legal bearing because that's not proof. However, Jay Glazer, a reporter for Fox Sports, went on a show, I think it was like the following week, on one of the pregame Sunday shows, and appeared to have a printout in front of him which read off the security report from the season prior. Like I said, Metcalf had complained about this same fan a year earlier, and it was in those in that original security report from the year prior that the alleged statement of slurs and stuff was used. I actually have the quote here from Jay Glazer. Quote, "I actually have the security communication between the Detroit Lions and Seattle Seahawks security from the game last year when DK Metcalf, when he was with the Seahawks, complained about that exact same fan to security. He asked that the fan be removed over derogatory comments. I'm not going to repeat what the comments are that are on here. Obviously, we don't condone ever hitting a fan or anybody else, but in this it says, when we investigated during the game, the individuals around him state and corroborated that the fan was being out of line and had indeed said these derogatory statements. They even asked us to remove the guy." Now, Glazer didn't say what those statements were, but he did insinuate pretty strongly that there were things that weren't fit for television that was in that NFL security report. But again, this was a year prior, and so that's where this gets a little bit messy, at least in my mind, when he's trying to prove. I mean, are they able to subpoena this NFL security report, or how does this type of thing even work in the collection of evidence, I guess you would call it?
Yeah, the attorneys would be able to get that in something called discovery, where you exchange documents and ask questions, take depositions to gather evidence, and that would be something that pretty much exactly what you said. If it was necessary to subpoena it, it could be subpoenaed, but it may not even be necessary to do that if attorneys are just like, "Hey, give me this," or I'll subpoena it. A lot of the times it's just like, "Okay, here you go."
Okay, fair enough. I think the interesting part of this is that I believe the NFL is one of the parties being sued. The Steelers are one of the parties being sued. The podcasts that I mentioned being sued, and then of course Metcalf himself. And so there are competing interests here in terms of I don't know exactly what each party is being sued for, because it's not like the NFL came out and intentionally, defamed this individual. But could is there an argument to be made maybe that there was negligence? How did they allow, why was security was right there? And that's one of the things that's been talked about a lot since this happened, is why the heck did security even allow this to happen? If there were things being yelled, why did they even allow it to get that close in the first place, et cetera, et cetera? And so that's the part. Maybe, I don't really think the NFL likes turning over documents unless they have to. So maybe it could come down to a subpoena in the end. But the fact that a reporter seemed to be reading off and this is a very credible reporter in the NFL space, seemed to be reading off a security report from the year prior. Do you think that would be sufficient to prove that it isn't false on the, I guess what I'm trying to get at, like a year prior, like could this security report play in Metcalf's favor?
I think it could, just in trying to determine what Ryan Kennedy, may have said on this occasion. I do think ultimately, though, the focus is on what was or was not said during this particular altercation, because if it turns out that he actually said things like that to Metcalf beforehand, but nobody said, "Hey, this is what he said to me," so no defamatory statement was made in the past, that wouldn't. I don't that wouldn't really have any bearing on whether any defamation happened in this particular instance. But it depends on what it may or may not show about what did happen in this instance, because if you end up confronting Ryan Kennedy with, hey, you've done this before, and you have an attorney that's really good at asking questions, you could end up uncovering, like, oh, turns out you actually did say that kind of same thing on this occasion. So it's not directly relevant, but it could play into how things develop with regard to this actual incident as opposed to the one in the past.
And so do these types of cases end up in court, or are they often settled outside of court? Is it totally dependent, or how do these typically go?
I would say it's dependent. Most lawsuits tend to settle, but it will all depend on it's always what the discovery process I mentioned earlier reveals, because based on what you find, everything could be incredibly obvious. And it's just, you wouldn't, as a defense attorney, you wouldn't settle a case where it's clear based on what you're finding out that that you could win without going to a trial. There's a procedure for that after discovery, where you see all the evidence, and there's essentially no way a jury could find in favor of a plaintiff. A defense attorney will try to use this procedure, a motion for summary judgment, they call it, to try to just say, we don't need to go to trial. We'll win and not owe anything. But it does depend on what discovery reveals. And I always think the main the main crux here, one of the biggest ones in defamation cases, is if the standard of you have to know it's false before you say it is the standard. It's really hard to win as a plaintiff if you're considered a public figure for a particular issue. And so if that standard applies, it's a much more favorable case for a defendant.
And the podcasts who are involved, so they would have to potentially subpoena communications between Metcalf and these podcasts to prove if Metcalf even did tell them about these alleged slurs in the altercation. I mean, how would that work? And also, would the podcasts, they don't necessarily have any way of verifying if it's true. Is it up to them to know not to broadcast something that's potentially that incendiary? Or, how's their liability?
As far as, figuring out what a podcaster did or did not know, that is something that you would also figure out or try to figure out during the discovery process, either by requesting recordings or, you know, if they like asking them where they heard this from could be in a something called an interrogatory where you send written questions to other parties or you take a deposition of the person who is the podcaster and ask them about, what did you know about this? Like, why'd you say this? What made you think that this was true? Or did you even think it was true, etc.? Things like that. So that's how you would figure out the extent to which they may or may not have known it was true or false, or if they were, unreasonable in determining whether it was false or not. So, but yeah, as far as like also there's an issue of to the extent to which you would foresee a defamatory statement being spread much more widely. Like if a podcast doesn't have that big of an audience, but then media catches on to it, like big media, and puts it everywhere. Should a podcaster have expected news media to latch on to their podcast and spread it around based on what the podcast says? So would the podcaster be responsible for the entire country knowing about it? Should they have foreseen that if they have a smaller podcast? Things like that. Those are all issues of the extent they may or may not be liable at all, or if so, how much.
Interesting. Yeah, I think it's important to remember for everybody listening that the NFL, at least reportedly, initially cleared the fan of any wrongdoing in the incident. And I think we kind of later came to rough conclusions that, okay, maybe he didn't say anything this incident. And then, of course, Jay Glazer revealed that maybe the stuff that was said was a year ago. And so that would explain potentially why the NFL cleared him of wrongdoing immediately. I think it was later reported that the NFL then started looking into it again. I don't know if new information surfaced or if they looked into the situation from the year prior. And I don't actually know whatever came of that. I don't know if it ever got reported on, but that was something that I found interesting as well. I don't know if I have too many other questions. I think, so there's like 4 or 5 different parties that are being sued. Is each one of those a different lawsuit that are completely separate?
They wouldn't be separate. They would probably be what is referred to as joined, and also consolidated, which means you kind of do like, just to put it simply, it means you kind of do everything together. Like all the parties would be involved in, the discovery process themselves, exchanging everything between everyone, kind of thing.
That from my perspective, then naming somebody like the NFL who potentially have access to incredibly good lawyers and grouping them into the same defendant pool seems like an interesting decision. Am I misguided there, or?
No, I don't think you're misguided. The only thing that I would mention about it, though, is the extent to which extremely talented NFL lawyers would be able necessarily to assist the other parties, because there could be conflicts of interest there, depending on what the best interest of each defendant is. I guess maybe an example of that would be, I know like the Steelers organization as a whole is being sued. My thought is that they're trying to say Metcalf is your employee and you're responsible for what your employee is doing as an employer. But for that to happen, you have to show that an employee was acting in the scope of their employment, and in that situation, it's possible the Steelers organization would have a conflict with like Metcalf's attorneys themselves, because one party would want to say, he was in the scope of his employment, and the other one would want to strenuously say no, so that they're not responsible for the individual actions.
Oh,
That's just
geez.
it's an example of a possibility, but of course,
Yeah.
at the same time, you would probably think like the Steelers organization wants to back their man. You're not going to get into fights against each other, but you know, just a lawyer thing to think about conflicts of interest. So
Yeah, interesting. So there's potentially competing interests from all 4 or 5 parties named, and could get a little messy on the side of trying to structure a proper defense for each side involved. Okay, well, I think we've answered most of the questions. The biggest takeaway I had from this is that 100 million, while it seems high and potentially, I mean, to me, just a person who's not familiar with the law at all, that seems absurdly high. But in the eyes of the law, there's a case. And, depending on what happens in discovery, that's going to be key. It sounds to me like they're maybe going to try and, I mean, it's impossible to say, but I would be surprised if this went into court. Nobody wants discovery. I think in general, nobody wants discovery, especially the NFL's been notoriously against having discovery in any kind of court. So there's often, a preference to settle in these situations. And, I would assume the fan probably doesn't want certain things coming to the light of day either, because according to the report, whether or not he said exactly what Metcalf said he said, it sounds like there was something he did that made NFL security get involved the year prior, and he probably doesn't want that coming to the light of day. So to me, it sounds like this is going to be headed towards a settlement, but we will just have to wait and see. Anything you wanted to add before we sign off here, Eric?
not that I can think of. So thank you for having me.
Yeah. Thank you for coming on. I hope this was informational to everybody out there. I don't know when the next step of this case is set to be. I think there's the criminal aspect of this as well, which I don't really know if it's worth getting into because it's a whole other can of worms. It wouldn't be... Well, real quick, Ryan Kennedy, would he be the one pressing charges, or how does that...
Technically, it's up to a prosecutor always to decide whether to press charges or not. So he himself can't just come out and say, I'm going to charge you with a crime.
Okay, so yeah, that's a whole other can of worms then. And not much really for us to talk about there. We all saw that he clearly did make some kind of physical contact with the fan. Whether or not that is criminal, I guess we'll leave that up to that prosecutor in Michigan. All right, well, that's everything for this show. Thank you guys for tuning in. I'm Ross McCorkle. On the line with me, Eric Donica, a lawyer in the state of Tennessee. Thank you guys for tuning in.